statute, which may result in grave injustice that the court, as occasion demands, have looked behind or pierced the corporate veil. Furthermore, it is right that the company is a separate legal person from its shareholders and directors. And under CAMA 2020, the company alone is ordinarily liable for its obligations. The court may pierce the corporate Hello? Can you hear
Yes,
me?
we can hear you, ma'am.
Okay.
We can hear you.
You can hear me, Lord.
Okay.
Yes, my Lord, we cannot hear you.
Okay. Sometimes a bail is lifted by legislation, not just by common law. In these cases, the court is not inventing liabilities, just enforcing the statute. The court may as well reach the same practical result without formally piercing the veil where the company is acting as an agent of a shareholder / parent company, or the company holds property as trustee / nominee for the real beneficial owner. In those cases, the court is saying the company is separate, but the facts show the assets or acts legally belongs to or was done for someone else. In the instant case, going by the claimant's pleading, he was employed in May 2001 and later confirmed for a 3-year contract. He was in the service of first defendant until he stepped down in February 2013. He was still engaged in the company until 2018. That is, he spent a total of about 17 years with the first defendant and continued in the same condition of contract until October 24th, 2018. Where the case gets interesting is where claimant pleaded that prior to the cessation date of October 2018, he was already engaged with second and third defendants, that is Pivot Gist and Broadview Engineering. And he tendered Exhibit C form, a letter from third defendant signed by the MD, Kehinde Bolodeoku, dated 1st of January 2019, where he was offered a 1-year employment as project director. The few clauses to note are: there was a 3-month termination notice or payment in lieu. The project site was Price Cement / Broadview Project. The monthly remuneration was $8,000, and there was a restrictive clause, and there was Medicare provided by Bupa. Still on the relationship between the defendants, the claimant tendered Exhibit C6, which are email correspondences between the claimant and one Juliana Ezesobom, head, Group HR Honeywell Group Ltd, with email address juliana.ezesobo@honeywellgroup.com, dated 11th of July 2016. The mail was sent at 15:14. And Friday, July 1st, 2016, this other mail was sent at 9:28 a.m. By a community reading of Exhibit C1 and C2, the claimant was still under the employment of the first defendant when he had this conversation bordering on monetizing his outstanding leave days, which had accumulated. And the officer who attended to this issue was the Group HR Honeywell Group Ltd. In other words, the claimant was in possession of a letter of appointment from the first defendant, but his personnel / HR/welfare issues were handled by the fourth defendant. Furthermore, the response to the demand letter of 11 November 2020 was written by Kehinde Bolodeoku on behalf of second defendant, same as that written on the 22nd day of January 2021 by the second defendant, while the third letter was written on behalf of the first defendant. During cross-examination, claimant admitted he had no contract with first defendant, neither was he an employee of second, third, or fourth defendant. On the other hand, DW1 admitted that she was employed by the first defendant in 2007, but currently works with the second defendant, that the second, third, and fourth defendants were sister companies, the standalone companies. The court noted that she also identified Kehinde Bolodeoku and admitted he worked for the second defendant. However, when she was confronted with Kehinde's email in Exhibit C7 as broadvieweng@gmail.com, which was created in the name of the third defendant, she had no response to the court. The court also noted that the claimant, in addition to an email created in the name of the first defendant, Dave_Obre@pivotengineering.com, also had an email in the name of the third defendant, DWO@broadvieweng.com. The court also noted that by Exhibit C5, after stepping down from the employment of first defendant and was engaged by the second and third defendant in 2019, his contract was renewed on the 7th day of February 2020, and it reads thus: I am pleased to inform you that your contract of employment with the company as a project director, in bracket, Main/Broadview project, has been renewed for another 6 months with effect from January the 1st, 2020 to June 2020. Signed, Kehinde Bolodeku, MD CEO. From the facts and evidence tendered in this case, and whether the second, third, and fourth defendants are liable for the claims arising from the claimant's contract with the second defendant, the defendants argue that each company, that is the first, second, third, and fourth, are separate and distinct legal entities with their own corporate personality. The defendants have also asserted that the defendants are not parties to the 11th May 2001 Employment Agreement Exhibit C1 or the 22nd November 2001 Confirmation Letter Exhibit C2, or between May 2001 and December 2018 Exhibit C4. The claimant's attempt to hold all defendants liable is speculative and ignore the lack of privity between them and the defendants for the majority of the period in question. It is the court's finding that there is a recurring decimal about the type of engagement claimant had with the defendants. Parties are in agreement that the first defendant issued the employment letter that governed the claimant between years 2001 and 2018. The court found that personnel, HR, welfare matters were attended to by the fourth defendant. Exhibit C6 speaks volumes to this finding, especially with regards to resolution of his leave arrears after the executive director or the fourth defendant had given a policy directive on leave and leave rollover. This was the same working relationship that was manifested and admitted by DW1 under cross-examination. In view of the above findings, this court is convinced that the second, third, and fourth defendants are jointly liable to the claimant for breach of the contractual agreement, I so hold. There is a relief sought for an order that the sum of $36,000 for 3 months' salary in lieu of notice be paid to the claimant. Salary is a reward for services rendered. Once a contract is terminated, even if wrongfully, the remedy is usually damages, that is salary in lieu of notice, rather than the continued payment of monthly salaries as if the employment continued, unless the claimant can prove a specific fixed-term contract that guaranteed payment regardless of service. Under Nigerian labor law, when a contract of employment specifies a notice period for termination, any termination forthwith without such notice of payment or payment in lieu is wrongful. In Skybank versus Adegun, the Supreme Court reaffirmed that the measure of damages for wrongful termination of employment is the amount the employee would have earned over the period of notice. Furthermore, Nwechi versus UBN PLC supports the principle that in a master-servant relationship, the court will award the salary for the notice period as the primary remedy for lack of notice. The claimant in proof of this claim in paragraph 24 pleaded that by virtue of his letter of confirmation Exhibit C2, he was entitled to 3 months notice or payment in lieu. The letter reads, and I quote, with the confirmation of the appointment, the company may terminate your appointment by giving you 3 months of notice, 3 months notice or payment in lieu, end of quotation. This court is mindful of the fact that the cessation letter Exhibit C3 threw up a lot of issues, which is before this court for determination. The claimant was by that letter dated the 24th of October 2018 put on notice with effect from 1st of July 2018 that his contract with the first defendant expired on the 30th day of September 2018. That salary should be paid during the notice period, that is July, August, and September. That October salary will be paid as normal. The salary will be discontinued effective 1st of October 2018, except for his housing, in bracket apartment, and domestic staff till December 2018. That in the event of a new contract on or before the 31st of December 2018, all arrears from November to December shall be paid, shall be fully paid, but there was no contract. But where no contract is secured, no payment will be made and the contract considered expired. In view of the issues raised in Exhibit C3, this court is saddled with a burden to determine whether termination can be retrospective and be said to be valid. The general principle is that parties must follow the procedure for termination laid down in the letter of employment. This was laid down in Idufeku versus Pfizer product citation provided, where the Supreme Court held that in a contract of employment, the element of unlawfulness arises where in carrying out the decision to terminate the employment, the employer or the employee fails, neglects, or refuses to adhere to the principles laid down by statute, that is in the case of contract with statutory labor, or the terms of the contract as contained in the letter of employment in the case of an ordinary contract of employment. The position of the law in Nigeria is that an employer cannot validly terminate an employee's contract of employment with retrospective effect. Although an employer may terminate employment with immediate effect or by giving the requisite notice or pay salary in lieu of notice, such termination only takes effect from the date it is communicated to the employee and not from an earlier date chosen by the employer. Any attempt to backdate the termination so as to deprive the employee of accrued salary, benefits, or other contractual rights is wrongful and of no legal effect. The Supreme Court in Underwater Engineering Company Limited versus Dudufen, citation provided, made it clear that a contract of employment cannot be determined retrospectively. Accordingly, any purported termination stated to take effect from a date earlier than the date of communication to the claimant is invalid to the extent of such retrospectivity, and the claimant remains entitled to all salaries, allowances, and benefits that accrued up to the date the termination was lawfully communicated. The claimant in this case was issued with a cessation letter on the 24th of October 2018 and was informed, and I quote, that effective 1st July 2018, you are put on notice that your contract with PACL formally expired by the 30th day of September 2018, end of quotation. In other words, the notice period was for the months of July, August, and September. Furthermore, the letter stated that his October salary would be paid. To the mind of the defendant, it had complied with the terms as stated in Exhibit C3, which is the confirmation letter to give 3 months notice. What the defendant failed to realize was that for the months of July, August, and September, the claimant had worked and served the defendant. There was no dispute as to this fact throughout trial. So for the defendant to regard those 3 months as notice is not only wrongful, but also displays as an unlawful labor practice. It is the intent and basis of the expanded mandate of this court, courtesy of Section 254 sub C sub 1 sub F of the Constitution, Third Alteration Act, to deal with issues of unfair labor practice, best practice of labor relations, and codified and uncodified international best practice and policy issues in labor and employment matters. See Section 254C sub 1 sub F and H of the Constitution, Third Alteration Act, effective March the 4th, 2011, which this court is poised to curtail whenever and however it rears up in adjudication. Such an unfair labor practice is actionable and attracts award of damages to assuage the pains of the victimized staff. See Leonard Onyibo versus Guinness Nigeria PLC, unrepeated suit number NICS/LA/639/2013, /2012. Judgment delivered on the 20th of September 2019 per Ogwanya J. The court is also mindful that as at 2018, the terms of contract governing the claimant's employment was as stated in the confirmation letter. The salary agreed was 7,500 per month, even though in paragraph 14 on the statement of fact, he pleaded that his monthly salary was $8,000. The defendant, in his statement of defense, never objected to the said amount. Neither was CW1 cross-examined to establish the actual amount paid as salary. It is tried that facts admitted need no further proof. The defendants are hereby directed to pay the sum of $36,000, being the 3-month salary in lieu of notice of termination. I so find and I hold. The first relief is for a declaration that the termination of the claimant's employment with the first defendant pursuant to the letter of 24th of October is unlawful, is wrong, null, and void. The claimant argues that his consultancy was an extension of his 201 employment contract and that the termination letter dated the 28th of October 2018 violated those terms. The defendant, on the other hand, maintains that the consultancy services was not governed by the 201 letter of confirmation of employment, as that contract related to its previous role as MD, which ended in February 2013, while the consultancy service actually ceased in September 2018 by mutual consent of both parties, making the claim of wrongful termination redundant. That the cessation letter was a formalization of a prior mutual agreement rather than a unilateral wrongful act. The strength of the claimant's argument lies in the distinction between the claimant's role as an employee, that's MD, and his subsequent role as a consultant, which are legally distinct categories of engagement. Going by the evidence standard before this court, the claimant's employment was governed by a valid written contract and a letter of confirmation dated 22nd of November. Under the terms of the employment, the claimant was entitled to a 3-month notice period prior to termination or payment of 3 months' salary in lieu of notice. The termination letter issued on the 24th of October terminated the employment on the 1st of September 2018, which constitutes a direct breach of the contractual requirement for notice. The defendant's failure to provide a requisite notice or the alternative payment in lieu, the termination is procedurally flawed and therefore wrongful. A termination without payment in lieu of notice constitutes a breach of contract. In master-servant relationships, the employer retains the right to terminate, but must provide a contractually agreed notice of payment of salary in lieu. Failure to do so renders the termination wrongful, though not null and void in a private contract. The first defendant issued the cessation letter on the 24th of October, but backdated the termination to July. In other words, it calculated July, August, September as the 3 months notice period. This court had earlier taken a decision in the earlier part of this judgment that was wrongful, and hereby states that the defendant's action was wrongful and that the claimant is entitled to damages equivalent to his salary for the period of notice he was denied. The equation for determination is whether the 2001 terms survived the 2013 transition. This court thinks so because both parties failed to tender subsequent contract of employment to cover the 2013 to 2018 period, where claimant served under consultancy status. Defendant has held doggedly that it was agreed at a meeting/discussion, but failed to show evidence where and how that decision was taken. This court hereby refuses to be swayed into adopting that line of argument. Under Nigerian law, labor law, when a contract of employment specifies a notice period for termination, any termination without such notice is wrongful. See again Skybank and Ejigun, where the Supreme Court confirmed this principle, and also Nwechi and UBN cited earlier. They also support the principle that in a master-servant relationship, the court will award the salary for the notice period as the primary remedy for lack of notice. In the circumstance, this court declares that the termination of the claimant's employment with the first defendant pursuant to the letter of 24th of October is wrongful, null, and void. Now, there is also a relief seeking for an order directing the defendants to pay $12,000 as unpaid salary for October 2018. This issue concerns the recovery of earned wages for the period worked in October 2018. By the principle of contract and labor law, an employee is entitled to remuneration for work done under the doctrine of quantum merit, as established in Akinola versus Lafarge Company, WAPCO Nigeria PLC. An employee is entitled to all earned wages up to the date of termination. In other words, he can claim payment for work actually performed. Parties are in agreement that claimant worked in the month of October up till the 24th day of the month. Since the claimant performed his duty for 24 days, then his right to payment for those days had vested and cannot be extinguished by the termination of the contract. It is informative to also note that the defendants in the cessation letter inserted a clause, amongst others, that October salary would be paid, and I quote, "But following due consideration and despite the company's tight finances, You shall be paid your October salary as normal. End of quotation. The salary for October is not in dispute as the document of Exhibit 6.3 speaks for itself. The defendants are hereby ordered to pay to the claimant the sum of 12,000 USD as unpaid salary for the month of October 2018. Relief 4 is for an order directing the defendants to pay 81,655.17 for 148 unused leave days. Claims for leave Claims for leaves are typically governed by the contract of service and internal policies. The claimant asserts that he accrued 148 unused leave days during his tenure as MD between 2001 and 2010. The defendants have argued that this claim, if they existed, were not carried over into the consultative phase. Any claims related to that period should have been settled or addressed at that time. The argument against this claim is also based on the lack of evidence that these leave days were authorized to be carried forward indefinitely or converted into cash payments years after the fact. To support this pleading, claimant has tendered Exhibit C6, which is a bundle of documents, email correspondences from one Koredo Olu Sunday, which is a tabular representation of claimant's outstanding leave days as of June 2015. Claimant also tendered email correspondence dated July 2016, where the defendant, through the head group HR, confirmed that, and I quote, "Your daily rate for the purpose of monetizing your outstanding leave days will be your net annual salary. But please be aware that outstanding leave days will only be considered up to 2010, where the transition period or leave rollover lapsed." End of quotation. Parties are in agreement. Claimant's tenure as MD of first defendant expired in 2013, and by the ED's directive on leave policy, claimant could only claim payment for leave days up to 2010 only. The court noted that by July 2015, this issue of outstanding leave was still being discussed. See Exhibit C6, where Soji Akintayo at Soji_Akintayo at pivotengineering.com forwarded the tabular report to Ehi_Okwegbuale at pivotengineering.com. By the next year, 2016, it also came up again before the fourth defendant in the person of head group HR, who admitted to this entitlement. Even the email of Kenny Bolodeoku at broadvieweng@gmail.com in October 2020 to Dave Aubrey at dwo@broadview.com shows that in his final days in Nigeria, this issue was still under discussion. There is no doubt in the mind of this court that prior to 2010, the claimant had accumulated 148 unused leave days. The executive director's order from the fourth defendant, Honeywell Group, in 2010 changed the leave policy to prevent future accumulation of leave days after 2010. See Exhibit C6. There is also evidence that the amount sought was never contested by the defendant. Due to the leave policy review, the payment was never made despite discussions. The claimant's entitlement to these days was confirmed in internal communications, especially emails dated 9th of July 2015 and 11th of July 2015. The monetary value of these 148 days is calculated at 81,656.17 USD, which remains unpaid despite the claimant's exit from the company. This court hereby grants this order directing the defendant to pay the sum of 81,655.71 USD for the total sum for unused leave days from 2001 to 2010. I so hold Relief 4 succeeds. Relief 5 is for the sum of 150,000 USD as general damages for undue delay, emotional trauma, distress, financial hardship, and embarrassment for failure to settle the debt. These are losses the law presumes to be the direct, natural, or probable consequence of the defendant's wrongful act. See also Udumosu versus ACB, Samoris versus Maja, and Union Bank of Nigeria versus Ajabule. Citations all provided. They are not specifically quantified quantifiable in monetary terms, but they are inferred by law to have resulted from the injury or wrong complained of. See Unity Bank versus Clayson, Meigari versus Raji, NPJ Farms versus Zenith Bank, citations all provided. Both all emphasizing that the quantum need not be pleaded and proven. However, the claimant must still prove the wrongful act of the defendant and that the damages claimed are a direct flow or consequence of that wrongful act. See also Agbola and ASB Investment, citation provided. The assessment of the quantum of general damages is primarily at the discretion of the court. The award is quantified by what, in the opinion of a reasonable person, is considered adequate compensation for the loss or inconvenience that flows naturally and generally presumed by law from the act or conduct of the defendant. It does not depend on calculations made and figures arrived at from specific items. While the wrongful act itself must be proven, the specific monetary value of general damages does not require strict pleading of proof, as it is presumed by law and assessed by the court based on what a reasonable person will consider adequate compensation. In the instant case, the court had pronounced earlier that the claimant who was exiting the services of the defendant after spending close to 17 years and was over the age of 65 years at that time, that his employment was wrongfully terminated, that the defendant failed to comply with the termination clause of Exhibit C2, which provides for 3 months notice period, that defendant backdated the termination of the contract and failed to pay salary in lieu of notice. Even the salary for the month claimant worked for was not paid and is subject to litigation, that the accrued leave allowance, even though agreed upon, was not paid. In the circumstance, this court is convinced that the claimant is entitled to general damages and the sum of $10,000 is hereby awarded against the defendant in favor of the claimant as general damages for acts constituting unfair labor practice by keeping the claimant in a state of financial hardship, emotional trauma, distress for over 6 years, I so hold. Relief 4 is for an order for the second defendant to pay $16,000 salary for November, December 2018. It is tried law that failure to pay for services rendered constitutes a breach of the employment contract and basic labor standard. It is clear from the cessation letter Exhibit C3 that claimant worked for the first defendant from January to 24th of October 2018. There is, however, a caveat for payment of November-December salary. The defendant made it clear that payment was dependent on its ability to secure a new contract on or before 31st of December 2018. Claimant did not tender any proof that the first defendant secured that expected contract. And going by the cessation letter dated the 24th of October, the claimant had ceased to be a staff of the first defendant as at the close of the year 2018. The defendant went ahead to issue another contract of employment for the year 2019, which commenced from January to December, Exhibit C4. The court noted that on receipt of this letter, there was no objection, neither was there a demand or a reminder for the November-December salary. In other words, the claimant considered to the proposed terms in Exhibit C4. The claimant cannot turn around to claim that it had forfeited, cannot turn around to claim what it had forfeited to the defendant. The court is also mindful that the defendant took full responsibility for his housing and domestic staff for the months of November and December 2018, but it was categorical about the salary for November, December 2018. This is the finding of the court. This relief therefore fails, I so hold. Relief 7 is for an order directing the defendants to provide insurance for 1 year from date of this judgment. In the alternative, pay the sum of 4 million naira 258,491.84 kobo to be refunded to the claimant. This issue pertains to the claimant's claim for the continuation of Avon Bupa medical insurance as part of his employment benefits due to the defendant's failure to provide coverage. This claim is based on the benefits package associated with this high-level position within the group. The entitlement to medical insurance depends on specific terms of the contract. If the insurance was a prerequisite of the office, it generally terminates with the office. To succeed in a claim for the monetary value, the claimant must prove that the benefit was vested or that the failure to provide it during the notice period resulted in a specific financial loss. Regarding the medical insurance, the defendants argue that there was no contractual obligation to provide Bupa medical coverage for the claimant and his spouse after the cessation of the consultancy in September 2018. The court notes that in Exhibit C6, which is a bundle of email correspondences, the claimant tendered an email dated 23rd of October 2020 at 8:18 addressed to Kenny Bolodeku, where he raised the one-year insurance coverage to, and I quote, to provide the very important 20-year historical cover we have enjoyed with Bupa Avon, which is critical to our securing our own new cover in 2018. So which is critical to our securing our own new cover in South Africa. If this is not available, we will not be able to secure medical cover in South Africa. End of quotation. This issue was raised by the claimant to prompt the defendant to make early payments to facilitate registration in South Africa, especially considering his age. The question then, did the defendant have an obligation to pay for post-employment medical insurance? This court does not think so. Was prompt payment of this entitlement a factor to ease medical insurance registration on relocation to South Africa? This court thinks so. Did the delay/non-payment result in the penalty paid by claimant in South Africa? This court thinks so too. In the circumstance, can this court grant an order to provide medical insurance for claimant and his wife for 1 year from date of this judgment? This relief shall be declined. It was never a term in the contract of employment. I so hold. The first arm of relief 7 fails. For the alternative relief of a refund of 4.258.49184 kobo for procurement of medical allowance for the first year, this court shall decline to grant this as it would amount to double compensation, since the claimant had already been awarded general damages in the tune of $10,000 for undue delay, emotional trauma, distress, financial hardship, and embarrassment for failure to settle the debt. I so hold. Relief 7 fails. For the cost of this suit was instituted in 2021 and called up for the first time before Honorable Justice Weneka on the 19th of November 2021. Thereafter, the case was adjourned for trial on the 14th of March 2022. This case was interlaced with series of amendments and adjournments. Even after trial was concluded, the case suffered further adjournments even at the stage of adoption of final written addresses. Well, finally, judgment is being read today, 25th day of March 2026. The cost of this suit is assessed at 600,000 naira only. The claimant is seeking 21% annual interest rate on the total judgment sum to account for the time value of the unpaid funds and the delay in justice. It is settled that post-judgment interest need not be specifically claimed before it is awarded, since it is statutory and the courts are empowered to award it at its discretion based on the stipulated rates. COAN versus Bronwen Energy Limited, citation provided, and also by Order 47 Rule 7 of the NICN Rules 2017. This court hereby awards 10% simple interest on the sums awarded until same is fully paid or liquidated. I so hold. Judgment is accordingly entered. All sums shall be paid within 30 days of this judgment. Judgment is accordingly entered.
We are very grateful, my Lord, for the well-considered judgment.
Lord, we are grateful for the judgment and pray that God grants the court the wisdom to continue to dispense justice in good health of body and mind. Thank you, my Lord.
My Lord, even though I cannot be heard, and in view of the fact that I have not smoked, I also add my gratitude to the court for the industry in dispensing this judgment and justice. I'm most grateful, my Lord.
I think my Lord has exited.
It appears so.
My lord may have dropped off, but I think the registrar is not subject
yes.
to further directive.
The court,
We
yes,
may
the
meet
registrar.
back. All right. Thank you so much. So goodbye, everyone.
All right. All right. Thank you.